The U.S. Department of Health and Human Services has issued a final rule that expands and consolidates enforcement over 25 healthcare conscience laws. This was quite extensive, and it includes parts of the Affordable Care Act. The largest focus of these conscience laws are on abortion services, assisted suicide, advance directives, and other types of medical care. This was big news coming out of the Department of Health and Human Services because it's creating new regulations, new enforcement over those regulations. It's increasing the authority of the Department of Health and Human Services to penalize participants that don't follow these laws, and it delegates responsibility to different agencies to do the same. What this rule is doing, and we had seen a draft rule before, a proposed rule, this is the final version of it that gives broad religious and moral exemptions to healthcare workers. It widens the type of person who can actually make an objection to serving an individual based on moral or religious grounds. It applies, when we say it widens the person it applies to, this is who it applies to: state governments and federally recognized American Indian tribes, hospitals and doctors' offices, front desk staff at hospitals and doctors' offices, so schedulers or admission staff, skilled nursing facilities and home health care providers, insurance companies, ambulance providers, pharmacists, pharmaceuticals, many other other employers that are non-health employers but who offer insurance to their employees. What it does, and let's take a little bit closer look at the effect of this, it adds definitions to terms, broadening the application of conscience laws. So discrimination is redefined in many of these laws. Healthcare entity, that broad list of who we're talking about, that was redefined as the healthcare entity, and referral is redefined as well. When we said it provides more enforcement and punishment, it's best to think of that in terms of an example. If a hospital has a front desk scheduler that has an objection to serving an individual because of their religious beliefs, if that hospital makes that scheduler put that patient on the calendar, that hospital could be punished because it didn't respect the religious objection of its front desk worker. So when we say it's got enforcement and punishment authority, that means that entities could be held responsible for not agreeing to the wishes of the employee of which it hires, who is then making a religious or moral objection. This includes, as a punishment, losing your federal funding. If you're an agency that gets an extensive amount of federal funding, by not complying with these conscience laws, you could lose that funding. There are other penalties as well. The Office of Civil Rights will investigate and enforce any conscience violations, and that is written into this final rule. Now, this could create a conflict of rights, as you might expect, patient rights versus healthcare worker rights. In that example we spoke about, an individual seeking admittance into a hospital who has a right to free care, if they're emergency room care or effective care, and they're meeting a scheduler or a nurse or someone in that healthcare environment that might make an objection to that care. You can see the two worlds of rights colliding. Now, it is not entirely clear how those conflicts could be resolved. You can bet they'll be resolved through the court system, but the way that this final rule is written, it seems to tip the scales just a little bit and whose rights win towards that healthcare worker's rights over the patient's rights. So that's something we're going to have to keep an eye on as this final rule is implemented. And it will be implemented. It takes effect 60 days from the publication in the Federal Register. Now, we said before this was a proposed rule before it became a final rule. There were over 240,000 public comments on the proposed rule with a lot of concerns and a lot of objections to broadening these conscience laws to this extent. But the final rule was issued nonetheless. Now, we said there would be case-by-case examples where litigation might follow suit. Well, San Francisco as a city has already sued on this rule, saying it is not something they want to enforce in their city. Other healthcare providers and municipalities have signaled they might join in as well. So this rule could be stopped before it even takes effect. Like we said, it'll take effect potentially, if it goes through, 60 days after publication. You can read the final rule. We link to it in the description below, but stay tuned. As more of these lawsuits play out, there could be updates on these conscience laws. If you have questions or want to stay in touch with us, you can follow us at healthwatchwisconsin.org.